Okay, welcome to my bonus material video. I'm going to go through the attachments. Here's attachments 1, West Virginia habeas corpus case number 14C900H. This was the habeas corpus they covered up. Of course, y'all know this is part of this right here to my 4th Circuit Appeals Court case. Now, the habeas corpus was handwritten, so if you apologize if you can't read my scrawl here. But you'll notice, again, I keep quoting, just like in my appeal, 27-6A-2 A, B, 1, 2, and 4. This is missing evidence. I go into how the prosecutor used surprise discovery from the CI transcript. And I go through here pointing out that the what the code says and the case numbers. Now, I also point out that, certain things were dismissed and the date on which they were dismissed. This right here would be the infamous child porn charges. It is the plaintiff's belief that the state was attempting to conceal misconduct and criminality with false arrest and false evidence to have the plaintiff committed by intentionally misleading Dr. Miller. This is not a new statement. This is what happened. This is the habeas corpus I filed. Then you have, the arrest warrant. Raleigh County warrant by Trooper Hayes, alleging offense committed on 16/22, August 2013. August 30th, search warrant acquired by Trooper Hayes. First page of Dr. Miller's report has bound over numbers for case numbers demonstrating, previous shit, I say double jeopardy. Also, incorrect charges. And the incident date as of February 25th, 2011. This is where he believes that the search warrant from 2011 was what the terrorist charges were brought on, which is completely different from the arrest warrant. And all this was a very locked down issue. And that's just for ground 2. Ground 1 was that the prosecutor violated this section of code. Ground 2, state's motion violated petitioner's right against double jeopardy, as already discussed in code, talking about how Dr. Miller did not have the proper sources. So he didn't even have what was originally meant to be used against me. Then we have ground 3, prosecutor failed to disclose evidence favorable to the plaintiff with the aid of the defendant, Judge Robert Burnside, that is her ex-husband, that the state intentionally withheld factual evidence to mislead Dr. Miller and also evidence of discovery that disproved much of the state's claims. Now, I go pointing this out, and you'll also notice that I mentioned Musa Dabana versus Kristen Keller Burnside. This is where she and Judge Burnside were sued for, conflict of interest, and the judge ruling in her favor. They still live together, still have kids together, still have communal property. Then we have ground 4. Motion was granted by coerced confession. Prosecutor Kristen Keller for the state was reliant on her ex-husband, Robert E. Burnside, to conceal evidence favorable to the plaintiff to threaten judicial authority over plaintiff to produce a coerced statement under oath that forced the plaintiff to violate oath to tell the truth, the whole truth, and nothing but the truth. Attaches evidence of both grounds 3 and 4 as material evidence was taken from the state's own discovery. Attachments are marked copy 1 through, I never finished, but copy 1, page 7 of Trooper Haynes' investigative report. Cites a blog I posted, Attacked by Stratagem, the socio-political politics of courts and corruption. This is the Black Dragon Ninjutsu blog, where talked about he provided misleading information, as the correct quote would be from copy 10. So threatening me with arrest for filing complaints only leads to me filing more complaints, and thus keeping everything in evidence. This is why I keep throwing up the letters that I wrote to Judge Berger in the federal case, because no matter how many times you argue, I'm going to bring this up again, that you knew that my attorney was covering up evidence, just like Kristen Keller did. This is the same pattern of criminal behavior from the state court all the way up to the criminal court. I point out that in violation of Baddock versus and Brady versus Ohio, which is actually Brady versus Maryland, and can only be overturned by the U.S. Supreme Court under Article 3, Section 2, Clause 2 of the U.S. Constitution. Outside the authority of the lower courts, Trooper Haynes' opinion, and this is where he goes into, well, he said this, and I think it means that, which is completely irrelevant. What you think is irrelevant. What matters is what was actually said. Copy 4, page 19 of Trooper Haynes' report for July 6, 2013. First paragraph quotes the plaintiff reference to dirty cops as dirty judges, prosecutors, magistrates, to a good old boy network which appears to be in existence, hinting at conspiracy by providing Dr. Miller incorrect and misleading information, failing to render evidence in accordance with the law, and forcing the plaintiff to violate oath to tell the truth, the whole truth, and nothing but the truth. This is compounded compared with copy 1516. So as you see, there's all these pieces of evidence that are actually attached to the file. What's really important is we get down here to Ashley Redding and the supposed agent Yancek. But I point out that Ashley Redding gave false testimony, all proven by court record in the 08 MAP-4-H transcript, which the state has attempted to conceal during the trial for case number, this was the stalking and assault charge, that the prosecutor used to subject the plaintiff to double jeopardy and fraudulent legal process with the help of the defendant, Judge Robert E. Burnside. Now, that's what I'm talking about. I brought this up. And, no, wait, was it Roger E. Burnside or was it Robert Hutchison? No, Robert Burnside, okay. Additionally, on page 35, there's Trooper Haynes as a witness to being assigned to investigate and meeting with Kristen Keller, Detective Morgan Bragg, so that if Kristen Keller was prosecuting and met with investigating officer Trooper Haynes, she was aware and had access to the publicly available information prior to Dr. Miller's evaluation and the plaintiff's arrest, reinforcing the evidence was hidden because it was gained by unlawful arrest. The state, with the aid of the defendant, unconstitutionally filed to disclose evidence and relied on a coerced statement from the defendant through abuse of judicial authority. Page 88, the CI transcript, Robert Whittemore speaking to an unidentified male voice about unknown instructions given to him. This is where he kept repeating himself. On page 11 of CI transcript, plaintiff says, "I didn't say I was going to shoot cops and judges. I don't have to do any of that. That's what they said. That's what they said I was going to do. I let them get away with it." If you look at what I actually said was that I was cut off by the CI because he didn't want me saying that I was not going to use violence. They were pushing me towards violence. Page 12, CI transcript, about complaints to the governor and a scandal drawing in the governor. This was not the present governor, but Governor Tomlin at the time. We have the August 17, 2013, his intent to bring case to court to discuss all the evidence of criminal misconduct. This goes back to the terroristic threats case because the evidence I put up there. They didn't want to have the videos. They didn't want to have the legal documentation that I brought up. Again, copy 10, attack by stratagem, Trooper Haynes misrepresented facts. Copy 11, continued reading blog. Copy 10, again, provides evidence Trooper Haynes misrepresented facts. As criminal complaint for says plaintiff quoted something he claimed was from the Bill of Rights. That was the preamble to the Bill of Rights. It does exist. It is real. Copy 11 shows Trooper Haynes once again represented the plaintiff's statement to push a private agenda as blog cited preamble to Bill of Rights from a U.S. government archive website. So to say that the preamble to the Bill of Rights doesn't exist, then why the fuck is it on a .gov website ran by the Smithsonian? Providing motive and reason for the state to conceal evidence gained by unlawful arrest, use of double jeopardy, trying to bring up the same case. Discovery list statements by plaintiff, reference police harassment from October 22. We have a list of continued discovery statements where I said they wanted me to use violence and no point pushing them. People looking to disgrace, losing careers, etc. Mentioned that I was pushed to violence. Now, again, we see this right here with the Avengers MC. So all of this right here shows a continuing pattern of, this is where they go back using the Black Dragon Fighting Society forms. Again, you see me citing these same codes that I listed in my federal thing for why the prosecutor, or why my commitment was in violation of West Virginia law. Now, and of course, we go back to naming all of these other people. The fact that they're tied to, where you have certain people who are basically put down as state informants, I guess you would say, tied to all these criminal organizations, which are also tied to the judges and the magistrates in Raleigh County. And again, I cite code. Now, all of this goes into the question of exactly why my attorney covered this up. Now, I'm going to show you that he covered this up in another page. Here's the June 5th motions hearing. So, attachment to June 5th motions hearing. This is where I outline the pages, where it identifies everything here on the cover sheet. But when you get here to it, here is the first sheet, which shows the case number and the date. We get into this whole thing where they're describing everything and basically laying down their basic write-off. Then you get to the second part of the challenge where it's under Heller. This is the main thing that he was focused on. But then we get to the point where he's talking about Dr. Miller. I had 2 evaluations I passed previously. Then I go back to a third with Dr. Miller. This is where the habeas corpus came in at. And so, again, you see original state court for terroristic threats. Again, you know, they're bringing this whole thing up to have me reevaluated at the time. The record was dated from Judge Burnside, Exhibit J. Given the statement, I think it's fair to say state requested the evaluation was done. This was Kristen Keller. By law, she, as the one person who requested the evaluation, she was required to provide the evidence, which she didn't do for the case itself. And in fact, when we get down here, that I was arrested in August 2013. I remained there until I was sent to Sharp Hospital in 2014. And this is where everything gets a little bit on the shady side. I keep saying that the case was dismissed, but, you know, as we get into it, they starts talking about it wasn't appealable. It wasn't appealed. When you get to this pause, this is where I brought up to my attorney, who even says it, Your Honor, Mr. Collins raises another issue with respect to that. He said he had requested, it's not that I requested an appeal while I was at Sharps Hospital. It was that I had filed a habeas corpus from the hospital. There's a whole conversation involving the prosecutors and the judge and my attorney making excuses for why the habeas corpus couldn't be addressed. Now, they go into this, and if you'll notice, this is where he says, shouldn't that have been addressed in state court and the appropriate objections made and preserved for all those things? I mean, how are we supposed to overrule what took place in state court? Well, we have the habeas corpus, but this was never brought up. He tried to go around it with some applied challenge stuff. But you basically get to the idea that it's like this, all right? And the judge even says, I think the as-applied challenge, maybe I'm wrong here, but I think the as-applied challenge, as this statute was applied to him, it was unconstitutionally applied to him, but I don't take that I can go back and review actions of the court and there that were not objected to, that were not preserved in any way whatsoever. But you've already seen the habeas corpus. So this is them covering this up. This is where they started saying that. Here we have part 2 of this, pages 19 and 20. And so from page 19, line 8, we start with Stephen Lowe. So we get into all this on count 1. And then we get down here to page 20, and I'm going to go back page 19 for a moment. All this is, Stephen Lowe addressing the biggest issue the court picked up on this is that in 2014, 2018, he didn't do anything to challenge the underlying commitment. Not only did he not appeal it, and I think the statement by the defendant here in court was he asked his lawyer to do so and he didn't do it. But additionally, not only did he not challenge the actual findings, but he never went through the procedure that exists in West Virginia state law to remove it from his background. We already know by West Virginia code, as I have on my motion, that I never lost my gun rights. So they have to prove that I lost my gun rights. Now, this being said, we get down here to, me talking about that, the code, and everything else. But let me show you something. As we turn back the pages, see Mr. Bumgard right here, when he's bringing his as-applied challenge, it is very akin to, I would say, like a habeas argument in the extent that. But we already know where the habeas argument is because we've already seen the habeas argument. The habeas argument is, of course, right here. This is the habeas argument. But they covered it up. They said it was almost like that, but he's cut off by the court. So then we get these 2 pages out of the way. And now we find ourselves at attachment 2. Trial transcript volume 2. There's a cover sheet for a cover sheet. But this page wants to stick together. But as you can tell, we're at item A of attachment 3. Page 32, line 11 to line 15, Stephen Lowe saying that Gilkerson said NICS doesn't cover mental health issues. And you have it right here, underlined. Trooper Gilkerson came in and told you that he took the firearm from him. The background check doesn't cover mental health issues, so he gave it back and ultimately found out that he was a prohibited person. It does cover mental health issues. That is the whole point of 922G. Now, here is attachment 3. Item B, line 30 or page 36, line 11. All right, line 11. Whoop. But if he wanted to possess a firearm, like what you see the form, there is a group of people that are prohibited persons. You're prohibited if you've ever been committed domestic violence. You are prohibited if you are a felon. Prohibited from getting a firearm. There's a list. And he marked that he qualified for everything, and he marked that he had not been found incompetent, committed. He might be wrong, ladies and gentlemen, but that was his thinking. Well, here's the thing. By state law, my commitment did not count, so I was not committed. Page 38, line 6 to line 16. Okay, when he has his encounter with the trooper's testimony, if I'm not mistaken, was he stops him because he's got this BB gun, the rifle. It was dark. He didn't know what it was. Somebody called it in. He checked it out. So, yeah, he stopped me. I have no problem with that stop. That stop was lawful. A bit racist because you're picking on a white boy in a trench coat because everybody seems to think if you wear a trench coat, you're automatically celebrating Columbine, which I wasn't. I've been wearing a trench coat since The Crow came out when I was in junior high. And then again, here on page 41, line 10 to line 21, Gilkerson makes reference to Gilkerson's testimony that the background check system did not contain the order that committed the petitioner to a mental health institution doesn't come back in the background check. That's because it was a temporary commitment protected by state law, unless the judge told me I lost my gun rights. And of course, this was page 41, line 10 to line 21. So, right here. Now, this I can't show you. It's the report. This is only the cover sheet. But you can see the report underneath it. You can't tell what it says because it is a sealed document. I'm going to move this over here while I adjust these pages so you don't see anything sealed, because if I show you sealed documents, that might get me in trouble. Here's attachment 5. This is page 69, line 16 to line 7325. Or page 73, line 25. All right, this is a whole conversation with the court, with Judge Berger. And yes, there's 2 cover sheets because it's that long. And yes, I'm citing code where it's all fucked up. Because here we have, if you choose to remain silent, I may instruct, they want you to remain silent. They don't want you to defend yourself. I do, Your Honor. All this stuff can be brought up. Do you understand that? Yeah, I had no prior felony convictions. I do, Your Honor. Any questions you have based on that? Yes, Your Honor, I do. All right. My previous counsel, David Bumgard, told the court that I had not tried to fight the commitment in state court. I had actually filed a habeas corpus. When I went through the process, the court order where it says it was deemed competent by Sharp says that it was deemed competency serves the same purpose as the habeas corpus. So there's like a whole bunch of evidence that was never allowed to be brought in because of that. I'm hoping to be brought in. My testimony clarifies some things. Me and the court go back and forth. I'm just going to hold this here and let you pause it and read. All right? So we go through this whole thing to where and you can see I'm citing Lewis versus United States and U.S. versus Cahill, where the Fourth Circuit has ruled concerning evidence, concerning I'm talking about bringing in evidence. Like I pointed out, Your Honor, I do not want to reopen those issues. I simply want to address the fact that I did file a habeas corpus. The order finding me Sharps, deeming me competent to stand, serve the same purpose as the habeas corpus. That is the court order. I mentioned violations to Giglio to the United States to provide false testimony that he did lie. She asked Mr. Campbell. Mr. Campbell basically covers his own ass. No, ma'am. At this time, we have document 88 is a rather long order, about an order entered by the court, and we have reviewed document 88. Mr. Collins and I have discussed this matter probably more than any other matter. And I informed him that I was of the opinion the court ruled and I couldn't get around that. Nor was I going to just directly violate the court's order and try it. The court says, nor was Mr. Bumgard able to get around it. If Mr. Bumgard filed his motion before Magistrate Abelhausen, and Abelhausen heard it before the judge, how can the judge make an order to Bumgard on what he can file? This is basically a confession that she had told Bumgard what to do. She had ordered him to conceal exculpatory evidence. Then they have Mr. Lowe in here saying if he filed a habeas corpus, if Sharps ultimately reached him and found him competent to stand trial, it's not relevant to all the issues today. It does, because West Virginia state law says that a temporary commitment does not count to prohibit your gun rights unless they tell you that you have lost your gun rights. So they have to prove this. To prove this, they either need a court order or a transcript from the court during that hearing to duly notify me that I lost my gun rights. If not, the temporary commitment does not count by state law. We've already covered this, but I'm going to throw it up here again. And then I mentioned that I would like the record to show, note at the court that I feel the rules would violate federal rules of criminal procedure. Now we get to the sentencing transcript, attachment 6. This is where Judge Berger prevented me from addressing federal statute 18 U.S.C. 927. This is what's such a huge hallmark, because, and I don't, oh yes, it is on page 36, line 13 to line 18. So let's go right here. Line 13. Beyond that, Your Honor, I think it's very much said everything I have to say in regards to that, but I do have a question. Why did you cut me off when I said that I had an issue with my attorney because I felt like he violated Federal Code 18 U.S.C. 927 by not acknowledging the state standard for prohibiting me from owning a firearm? Now, we know what 927 is. You can go back to the original video. Here we have initial appearance in the statements of ATF agent Viep. Oh, can't show you that. It's sealed. See, sealed, document number. This is part of the letters that I wrote to Judge Berger. So let's get that out of the way. What else is over here? Ooh, more of the letters I wrote to Judge Berger. Initial appearance testimony by Agent Viep. Let's see, what do we have back here? Oh, more sealed shit. More sealed shit. Hold on, let me go through this real quick, so I don't violate any federal laws by showing you material evidence that has been sealed by the court, showing that Judge Berger knew what was being done to me. Aha.